particular case, a silent movie company go from doing silent movies to doing talkies. Wonderful feeling, wonderful film, wonderful singing, wonderful dancing, etc. And we're now going to talk about young people and the Mental Capacity Act, because trying to work out how the Mental Capacity Act fits in for young people is not a glorious feeling, and it certainly feels like you are singing in the rain, because there is so much to try and work out and unpick. I'm going to explain how the sort of system works in a minute. The starting point is 16 and 17-year-olds who lack mental capacity to make decisions for themselves can either be, inverted commas, managed in the family court, or they can be managed in the court of protection. And you can transfer between the two jurisdictions by way of what's called the Mental Capacity Act Transfer of Proceedings Order 2007. When you transfer between the two courts is set out in two authorities, being a local authority RM and AF Children number 2, both of which set out the type of factors that the court will consider when determining what is the correct jurisdiction for a young person to be considered in. So the Court of Protection, before somebody is 16 years of age, doesn't have jurisdiction unless A, it's a matter that relates to their property and affairs, so essentially money, and B, it is thought that once that person reaches the age of 18, they will still lack capacity in respect of their money. So it tends to be cases involving people who've had things like birthing injuries, or been the victim of some sort of personal injury as a child. They've got a large amount of money. They lack capacity, and they're always going to lack capacity to deal with that personal injury award. The Court of Protection does have authority to make decisions in respect of those young people's money, but not their welfare. If it's someone who's 16 to 18, if P lacks capacity to make decisions for themselves, and the Mental Capacity Act is thought to be the most appropriate framework, then in those circumstances, the Court of Protection will hear a case rather than the family court. There are, if you are a children's social worker, there are advantages and disadvantages to both of the jurisdictions. To give you a heads up, there are, for example, if you need secure accommodation, then there is no secure accommodation order that can be made by the Court of Protection. Someone can't go to a secure children's home on a Court of Protection order, and so on and so forth. So 16 to 18-year-olds is difficult, but if a 16 to 18-year-old lacks capacity to make decisions for themselves, the Court of Protection can make it, and the Court of Protection is sometimes the most appropriate venue for P. I would say, from my view, the Court of Protection is most likely to be the most appropriate venue for a court case about a young person if their lack of capacity is likely to be lifelong. That's my view. That's slightly reflected in some of the authorities as well. Bloopers. So one of the things that we see a lot, and we've seen a lot recently, is that young people are being managed up until their 18th birthday under the Children Act by the family court. And then before their 18th birthday, there is a sudden panic, and there is suddenly applications being made to the Court of Protection to get things sorted out. Just so you're aware, for those of you who are familiar with the streamline process for applying for community deprivation of liberty, all the 16 and 17-year-olds have now been pulled out of the REX streamlined procedure because the senior judge of the Court of Protection, Her Honour Judge Hilda, has determined that those cases require active consideration by a judge, and they require 16 and 17-year-olds to be properly represented before the court. So certainly there are issues with 16 and 17-year-olds. There are issues with cliff edges in respect of what happens when they transition. And I would say that the period when someone turns their 18th birthday is becoming problematic within the Court of Protection, because transition arrangements and applications are not being made far enough in advance before someone's 16th or their 18th birthday. I'd also highlight, if any of you are sort of inverted commas pure children's social workers, I'd also highlight that in circumstances where you become aware of a child who, for example, has a large personal injury award that is in some respect being mishandled by a parent, or there is money there for some adaptation to be made to a house that's not being made, or money there for a house to be purchased that's not being done, those children are not being properly cared for, from the sense that local authorities don't involve themselves in those cases, whereas children's social workers have identified in the past cases where children's money is being inappropriately spent, especially by parents, sometimes by siblings, and nothing's being done about it. And again, I would suggest that there is a legal responsibility on the local authority to step in those types of case. And I've done one before where there was a young person who I think was 12, and one of their family members was trying to install a very, very fancy pool and a very elaborate bedroom suite for themselves in a house that was being built with their child's money, which is clearly inappropriate. So how do you improve your practice? If you're a beginner to Mental Capacity Act, you need to go through your caseload. And if you've got people turning 16 and 18, you diarise legal planning meetings way before they turn and their age changes. Because I tell you now, the cases are complex. They need proper planning, and that planning needs to be done in advance with the input of legal. Secondly, if you are someone who is sort of further along in your practice, I would ask you to think about how the 16 and 17-year-olds that your team is looking after are being deprived of their liberty, and consider how that's being authorised. Again, experience, especially over last summer, was we were getting, I spent probably about a month and a half, 6 weeks, where I was dealing with back-to-back urgent cases with 16, 17-year-olds because things had gone wrong in their placements in the community. They weren't properly or lawfully deprived of their liberty in the community. Then they were being sectioned. Then they were being discharged from section. It just became a total nightmare. And similarly, one of the themes which I am told is becoming an increasing concern for a number of statutory bodies is how the deprivation of liberty for young people is being authorised when they're placed at residential schools. So if you've got a 16 or a 25-year-old at a residential school, 16 to 25-year-old at a residential school, so a special school, and they're doled there, there has to be some interplay between education and social work teams as to how that deprivation of liberty is being authorised, because the parents can't authorise the deprivation of liberty, deputy can't authorise the deprivation of liberty, and the education team at the local authority can't authorise the deprivation of liberty, nor can the education tribunal. So if the first tier tribunal send a 17-year-old, 18-year-old off to a residential school and they lack capacity and they're deprived of their liberty there, the tribunal cannot authorise that. All right, train spotting, an absolute favourite of mine, all about the Edinburgh drug scene. You'll all remember Ewan McGregor looking particularly ill during that film. It is an absolute classic. It's very, very good. And I want to talk to you a little bit about drugs, alcohol, and mental capacity, because again, it's something which causes a problem. Last year, the Court of Protection stepped in slightly in that it provided the decision in London Borough of Tower Hamlets and PB, and in that case set out how to approach issues in respect of alcohol, and essentially said that really in the vast majority of cases, it's not really about whether or not a person has capacity to make a decision about drinking. It's rather how you think about their wider care planning. And also there at that stage, I just pause to remind you all, the court of protection you cannot make a best interest decision about whether or not it's in someone's best interest to purchase and use illegal drugs. So the court of protection can only make decisions which P themselves could have made, i.e. lawful decisions. So if you've got a problem with P accessing the community to purchase drugs, or you've got drug dealers targeting P, that tends to be managed through a capacity to make decisions as to care or capacity to make decisions as to contact. The things that we find are going wrong in these types of cases in respect of capacity is that people find it difficult to separate out what is causing the functional deficit, i.e., is it the drugs and alcohol causing the loss of functioning, or is it something pre-existing or coexisting, or is it something relating, for example, to withdrawal? So the symptoms of drug or alcohol abuse can cause a loss of functioning. So if somebody, for example, is in withdrawal from heroin and that's having an impact on their decision making, that can be sufficient for the purposes of the Mental Capacity Act to say that a person has lost has been a cause for the loss of someone's functioning. In respect of how to improve your practice in that regard, really good starting point if you're a beginner in alcohol cases is there's a website called Alcohol Change UK. They produce a series of resources and toolkits, including one in respect to the Mental Capacity Act, which deals with alcohol-related brain damage. That's really good. Another thing that I would ask you to think about if you're an intermediate practitioner, and if you've got someone who misuses alcohol potentially, or someone with Korsakoff's or something like that, is how alcohol reduction strategies can be incorporated into a care plan, rather than guillotining someone and saying you can't have alcohol anymore, you're going to a dry care home. And then finally, one of the things which I think is interesting to do, if you've got a team who are dealing with people who are likely to go through alcohol withdrawal, if you ask one of the advanced practitioners in mental capacity to produce a checklist in respect of how alcohol withdrawal can impact on mental capacity and how you can plan for that. Alcohol withdrawal, the symptoms around it, can have a huge impact on someone's mental capacity. And I did an inquest on that where the ambulance service in the Midlands were absolutely criticised by the coroner. And in fact, nationally, the paramedics, nationally, the approach to paramedics and alcohol withdrawal has had to be revised because of it. It does have a real impact on someone's ability to make decisions, and indeed their sort of general presentation and well-being. So Green Book, if you haven't seen it, you must go and see it. Really interesting about two cultures, well, about three cultures actually. So an Italian American, the Deep South, or America's Deep South in the 60s, and about a black man who is a absolute sort of expert classical pianist who then has to go around venues where he's not welcome. And again, really, culture and beliefs is featured within Section 4 of the Mental Capacity Act. It's something that you're required to think about. And what the Supreme Court has said is you're always required to think about best interest decisions through the lens of the person who the decision is being made for. So in Aintree, it was a patient. What we tend to get wrong in this regard is that we think about what someone's current wishes and feelings are, as opposed to any previous beliefs and values. So we say, the person wants this now, that will make them happy. And we apply weight to that, rather than thinking perhaps, because it's more difficult, to think about their wider religious, cultural, moral, or political background. And sometimes what we do as well is we focus on what the family want. So in the case of IH, observance of Muslim practice, there was a dispute about whether or not particular Muslim practices should be imposed on IH himself, even though he's had a lifelong disability and hasn't chosen to be part of the Islamic faith. So there are a number of cases which are sort of helpful to improve your practice in this regard. If you're a beginner, there's a really interesting case called Re-P, capacity to tithe inheritance. And that was about a man who wanted to give away 10% of his money to the Mormon church. And in that case, District Judge Eldergill goes through the approach to sort of religious concerns, how they should impact on best interests decision making. If you're an intermediate practitioner, one of the really interesting cases, which is quite recent, is VO, AO, and others, which is about someone coming from a care home to die. And that talks about Nigerian culture and expectations around death, and is really helpful. And then finally, if you're someone who's an advanced practitioner, again, sort of thinking about forward planning and toolkit making for other people, think about whether or not reading the case of IH, you could develop a sort of toolkit or a flowchart that would help you determine how to approach someone's religious beliefs. Are they their religious beliefs, or are they religious beliefs of family members, and how that would operate within Section 4 without essentially being judgmental. Finally, again, I'm sorry if you're a Leo fan, but Inception, I think, is personally one of the worst films ever made. But it's apparently really popular, top 100 of all time. Inception is all about coercion, control, and undue influence. And in that, you have a thief who essentially implants ideas into the mind of a CEO of a company. And the sort of the implanting of ideas and influence and control is what the mental capacity isn't necessarily about. So I've mentioned Re-EOA to you earlier, and there's a couple of authorities there, Re-DL and the local authority versus BF. And effectively, what undue influence, coercion and control is about is an external influence taking away P's capacity. So again, going back to that concept earlier, if you're a basic sort of learner practitioner with mental capacity, if it's something internal caused by the mind or brain, it's a lack of capacity. If it's something external, somebody's coming along coercing and controlling someone, then it's not the mental capacity act because it's not caused by a disorder of the mind or brain. And so in those scenarios, we have to look to other legal frameworks other than the Mental Capacity Act, or we deal with it under what's known as the inherent jurisdiction of the High Court, which is basically a very wide safety net if there isn't any statute in place which can protect P. And what we do find is that sometimes people are shoehorned into the Mental Capacity Act because you as practitioners identify that someone's at terrible risk, and the Mental Capacity Act is what comes naturally to you. And you say, well, the person lacks capacity to make decisions as to contact, whereas in truth, the person can make decisions as to contact. They've just been coerced and controlled by someone else. And again, we tend to find that the inherent jurisdiction of the High Court is sometimes misused because other statutory bodies don't come on board and actually do their job. And sometimes local authorities are sort of backed into a corner, but they shouldn't be. And the inherent jurisdiction isn't there if there's a statute that can deal with it. So if someone can avail themselves of a domestic violence prevention order or an FMPO or something like that, then we use that before we use the inherent jurisdiction being the backstop, the great safety net. So there is an online free guide for social workers to identify coercive control, and I've put the link there. If you're an intermediate practitioner and you've got a case which involves both coercive control but also someone with a disorder of the mind or brain, can I send you back to my case of REOA that I mentioned earlier today? That's about autism and indoctrination. There's a lot of information in that and legal sort of direction in that about how to approach those cases. And if you're an advanced practitioner, it's really helpful if you can think about what other legislative mechanisms might be available to exist to protect P. What else can you point someone towards before going to the inherent jurisdiction? Because you only go to the inherent jurisdiction if the Mental Capacity Act doesn't apply, the Children Act doesn't apply, no other act is there. It is your sort of backstop to protect that person who's had decision making taken away from them by somebody else. So finally, on my Hollywood theme, Alfred Hitchcock, and a couple of quotes. I love the first one. A human is not poor if he can still laugh, and talking essentially about, you know, in everything that we do in respect to people who lack capacity, joy is actually something really important, and please don't undervalue that. And then finally, for all of you who are scared about taking decisions in respect of risk and potentially giving way to a risky situation, there is no terror in the bang, only in the anticipation of it. So be brave, be bold, and it is good to talk. So events like this are really helpful. I wish we were in person, but we're not. Twitter is great. Social workers and lawyers, I think, talk more on Twitter than they do in any other forum. That's great. LinkedIn is great too. And I'm always available on good old-fashioned email. Then finally, my final plug, 39 Essex, we produce case summaries, which are free, and you can click on our website. And also, we produce mental capacity resources. So guides to capacity assessments, guides to the inherent jurisdiction, guides to best interest decision making. And we do that for free, again, just to try and improve your practice and the lives of P. I've slightly overrun, I'm afraid. I didn't quite manage 90 minutes, but I understand that the average length of a sort of Hollywood film is probably about 100. So I'm there. So through the magic of Hollywood, I hope I've taught you all something this morning, beginning, intermediate or advanced, about the Mental Capacity Act. And I hope you feel a bit more confident about it, and rather less 10 things I hate about you, but more positive than before. So thank you for my invitation, and I hope you will stay on and listen to the questions and answers.
Thank you, Ian. That's been fabulous. Really, really brilliant presentation, and just a wonderful tour around the Mental Capacity Act. We have got a few questions that are posed for you. Did you want to do those now, or do you want to do it at the end after the case examples that we have?
Let's do the case examples together, and then we'll do it all at the end.
Fabulous. Okay, so we have two practitioners who are part of the partnership who are going to present some live case examples to you today. The first one is going to be presented by Rachel from Dorset Council, and the second one will be from Cheryl, who's at Bournemouth, Christchurch and Poole Council. The first one is in relation to an older adult, and the second one is in relation to a younger adult. So I'm going to hand over to Rachel. Are you happy to share your screen, Rachel? Let's see if we can get it to work.
Yep, I'm just going to get that up now.
Fabulous. And we have been collating your questions throughout the morning, so we will bring them all together towards the end for a panel. Brilliant. I'll hand over to you, Rachel.
Okay. Thank you very much. So I'm Rachel Wilkinson. I'm one of the MCA advisors in the Mental Capacity Act team in Dorset Council. This presentation that I'm going to share with you, some of you might have heard before at one of our webinars, but I was asked to do it again. It was well received last time, so hopefully you'll find it helpful again. We do run monthly webinars in our team, and the next one is on the 6th of July. So if you are interested in coming to one of them, then do let the team know. So whenever we're talking about the Mental Capacity Act, I just think it's always helpful just to remind ourselves of those 5 statutory principles. So, number 1, a person must be assumed to have capacity unless it is established that they lack capacity. So it is never for the person themselves to prove their own capacity. It's for the person assessing to establish why, on the balance of probabilities, so more likely than not, that the person lacks capacity. The other important point to make here is, though, if we do have a reason to believe that a person lacks capacity on a specific decision, we should be completing that assessment. So we just need to be mindful, if we are concerned, then we should be completing that assessment. The next step is a person is not to be treated as unable to make a decision unless all practicable steps to help them to do so have been taken without success. So this is a really important principle. We must take all the steps we can to help someone make their own decision. So just think about things like communication methods, the time of day, whether they would feel more comfortable with someone there with them or not. And information, so what Ian was saying earlier about that relevant information, what can we give to that person, what information and what format can that be in? And it's really important to document that as well, because sometimes we do these things automatically. So it's just recording that and showing what we have done to help that person. The next step we've got is a person is not to be treated as unable to make a decision merely because they make an unwise decision. So, you know, we're all individuals. We all make unwise decisions from time to time. I'm sure we can all think of ones that we've made. But an unwise decision alone does not mean that a person lacks capacity. We're going on to the best interest aspect of it now. So number 4 principle, an act done or decision made under this act for or on behalf of a person who lacks capacity must be done or made in their best interests. So really find out what's important to that person. You know, consult with other people as well if we can. Anyone that's named by that person that particularly they want us to consult with, any past, present wishes and feelings that we can find out, any values that we need to consider in that aspect. And the last one, number 5, so before the act is done or the decision made, regard must be had to whether the purpose for which it is needed can be effectively achieved in a way that is less restrictive of the person's rights and freedom of action. So really try and think about that word purpose. What is it that we're trying to achieve? And give thought to whether this can be done in a way that is less restrictive. So I'm just going to look at a case study now, and we can see how all those principles apply, and hopefully some of the things that Ian was talking about as well. So I've got a case here that I worked on. This is Mr. A, an 83-year-old man. He was living at home with some informal support, and he was admitted to hospital and discharged to a care home. So at the care home, a deprivation of liberty safeguards, DOLS, was put in place. And the doctor involved in that assessed Mr. A as lacking capacity in relation to the DOLS. And Mr. A was objecting to his placement and asking to go home. When he received his DOLS, he actually rang into the team to highlight that he wanted to object it. But he was also appointed a paid representative, and they supported him to raise a Section 21A challenge to appeal the DOLS authorisation through the Court of Protection. So it really shows the importance of the DOLS there, and it gives that person that right to appeal. And as part of his appeal, this is where I was asked to do some assessments. So there was 4 assessments that I looked at. That was in relation to accommodation, care and treatment, alcohol use, COVID-19 and the Court of Protection process. So I'm just going to look at the decision on the accommodation, care and treatment, and I'm just going to run through that assessment. So I've got the form A up here. This is the form that we use in Dorset Council to record our capacity assessments. And I'll just start off with, we've got just the basic information at the top, and then we've got the question of the specific decision. So does Mr. A have capacity to make the decision on his accommodation, care and treatment? I'll just go on to the next page. The next part asks, I believe that the person has an impairment of or a disturbance in the functioning of the mind or brain, which may affect their ability to make this decision. This appears, oh, my slides have just gone off. Just a moment.
You're back on, Rachel.
Yeah, I don't know what happened there with the slides. I'll just go back to where I was. The slides back.
They're not showing slideshow, but they are on the screen.
On that.
That's it.
Thank you. Not sure what happened there. They just seem to disappear.
Good old technology.
Yeah. So yeah, so we just got to the bit about the disturbance or function in the mind or brain, and this is due to, or appears to be due to, and then I've put in for Mr. A what the situation is there. So Mr. A does not have a confirmed cognitive impairment diagnosis, and the previous DOLS Form 4 stated possible Korsakoff's dementia due to alcohol use. So it's just mentioning there that a person doesn't have to have a confirmed diagnosis. We just have to have a reasonable belief about that there is an impairment, disturbance or functioning in the mind or brain. I'm just going to run through now the form itself and the 4 stages. So we've got understand the information relevant to the decision. So does the person have a general understanding of the decision they need to make and why they need to make it? So what I've put here is I've put a statement there that Mr. A can understand the information on where he currently lives and the support that he receives in the nursing home. And Mr. A expressed his wishes are to return home. He discussed the current support he has in place and understood any additional care and support he would need at home. I'm just going to go on to the next page there so we can take a look at that a little bit more. So I asked Mr. A, can you tell me where you are now? Mr. A said the name of the care home. I asked Mr. A, can you tell me how long you have been here? He said about 3 months. It's a long time. I think it's since March. Mr. A said, in here, you can lose track of time. Every day is the same. Mr. A said, I know it's the 2nd of December today, if you're going to ask me that next. So he had quite a sense of humour, and he was sort of saying that in a joking way because people had obviously asked him that question at some point. So Mr. A went on to explain that he keeps track of the date through his daily newspaper. I informed Mr. A, I understand it was the 10th of July when he moved in. Mr. A accepted this. He said it was his birthday on the 5th of July. And I've just gone on to document that conversation that I had with him and sort of just put in those things that he said. So it's really helpful just to include some of that conversation that's relevant to what you're discussing. Just going to look at retain the information long enough to make the decision next. So on this part, I've just put in about what the doctor put in their report and how Mr. A was presenting now. So on the retain the information, on the Mental Capacity Act assessment report completed by Dr. B, it states Mr. A was unable to accept the information that contradicted his memory of events, even with prompting, and he did not change his views about when he came into the hospital or how he was managing at home in the lead up to that admission. The lack of acceptance impacts on his ability to make decisions and about the care he needs and where this might be received. So I've just gone on to say how Mr. A was on this assessment. So on this assessment, Mr. A did accept the information when this was explained to him. He could not quite remember when he moved into the nursing home. He thought it was March 2020. I explained to Mr. A that he moved into the home in July 2020. He accepted this. He acknowledged it was difficult to keep track of the time in the care home. I asked him again later if he could remember the information I had told him on when he came into the home. He said no at first. They then said July, I think, showing that he had in fact retained and recalled this. And we started just talking a little bit more then about the support that he'd had previously at home. And sort of Mr. A, I've put there about how he followed the conversation throughout my meeting with him and could retain and relay the information being discussed. An important point that I thought here was that he relayed this back to me. He said, I'm going to ring my son later to say that you have been to see me. And he correctly relayed a summary of our conversation and the reason I had visited him. And when he talked about returning there, I asked if he could tell me where he lived and things like that, and he correctly told me where he lived and how long he had lived there. So he'd retained a lot of the information that we talked about and retained information about how he was at home. The next part is around using or weighing the information to make the decision. So again, I've documented what the doctor had put in their previous assessment for the DOLS. So Dr. B in the DOLS form 4 said he mistakenly considers that he could transfer and walk independently. He said, I can't walk properly because I broke my leg. I want to be able to walk properly as I did in the past with a Zimmer frame or trolley. I don't need to be hoisted all the time. I got out of bed myself and got onto the wheelchair. Then later they returned me to bed with the hoist. So the staff nurse at that point clarified that this was not correct and perhaps showed that Mr. A is confabulating. Well, on the assessment that I did when talking about Mr. Mobility, Mr. A said he was sat in the wheelchair today to talk to me. He had been given his Zimmer and he can walk with his Zimmer. And the nurse on this occasion confirmed this and said that he was really good with his Zimmer frame. And he uses the wheelchair and to carry something, he said, and I witnessed him doing this during our conversation. So he was relaying the correct information there. So on this weighing up, I've gone on to talk a little bit more about at home. So that's where we're giving people those options. So thinking again about those practicable steps and the information and options that someone needs. So I asked Mr. A, what help do you think you would need at home? And Mr. A said, I have a very good carer who visits on a Monday and Wednesday and Friday. He talked about how he hadn't visited him in the care home just because he was worried about the virus. And he talked about how often his son visits. I then asked Mr. A to think about the help that he currently receives here at the nursing home and that we have discussed, and to try and think about that help that he would need at home. And I'll just go on to the next page again. So that's just where I've said about that. So we're talking through what sort of help he would need at home. And I said that I understand that a package of care 3 times a day was being considered for him at home, and asked him what his thoughts would be on this. And he said he would accept this if something, he said it could help if something happened to see, and we discussed the benefits of having some extra support in place. So he was weighing up that information then, and he's got his carer C who can help. But if that person wasn't available, then he's got the other care package. So that just really demonstrated him weighing that up. So when we talked a little bit more about what he needs at home, his family support, and I spoke to him then about the nursing home that he was currently in was closing. And again, this was another option to discuss with him. He was offered a move to another care home. And I asked what his thoughts were on this. And Mr. A said, no, I don't need it because I've got my own home. There is no need for me to go in to another rest home. Mr. A was clear in expressing his wishes and said, I don't want to die in a bloody nursing home. I want to die in my own home. So just on the last bit of communicate the decision, I asked Mr. A what is important to him, and he said going home. Mr. A said, I feel if I go home and have the care, it will do me more good. I will have all my bits and pieces and all my friends, and I will live longer at home and not in a care home. So he's really sort of expressing his wishes clearly there. So just towards the end of this assessment, this talks about optimizing understanding and maximizing capacity. So I've just put a little bit there again in relation to those practicable steps. I contacted the nursing home to arrange a time to visit. Mr. A was expecting me when I arrived. He was keen to talk to me and happy to talk through the decisions required. I explained my role, and the reasons I was visiting him was to assess his capacity on the decision of accommodation, care and treatment. So really important point there as well, just to explain our role, the reason we're there, what we're assessing. And he was offered to have the RGN present or not, and he said that he would prefer her to be present. And we were sat in a quiet room with no other distractions, and I rephrased and repeated the questions where needed. And the conclusion I've just put here towards the bottom, and it just talks a bit about the background of Mr. A. So this just really gives his story and shows what's important to him, really. So Mr. A is an 83-year-old man, and he was born in Dorset and spent most of his life living there. The bit about how he was admitted to hospital and how he came into the care home. So just carrying on with my conclusion and summary, so Mr. A, throughout his stay in the nursing home, has been consistent in expressing his wishes as a return home and raised a Section 21A challenge in relation to doles. I've just said a little bit how he knows where he is and talking about the daily living task and that he is willing to accept that offer of care at home. I consulted with the nurse who explained that Mr. A was very unwell when he first moved into the home, and his cognition and capacity has improved a lot since he's been there. He does need a little bit more help than he thinks, for example, with personal care and medication. But Mr. A has always been consistent about his wishes to go home, and the RGN's view is that he now has capacity. So my assessment is that Mr. A understands the salient factors. He understands he has care and support in the nursing home and understood and is willing to accept the care and support he would need at home to minimise risks to him. Mr. A was able to clearly express his wishes, stating, "I don't want to die in a bloody nursing home. I want to die in my own home." And I've linked this into the case law. It has similarities to CC versus KK and STCC, which states, "Likewise, I consider her frank observation that if I fall over and die on the floor, then I die on the floor, demonstrates to me that she is aware of and has weighed up the greater risk of physical harm if she goes home." And I venture to think that many and probably most people in her position would take a similar view. So that linked in with what Mr. A was saying. I've also sort of documented further similarities to that case. When considering KK's capacity to weigh up the options for her future residence, I adopt the approach of Markia J in LBJ versus RYJ, namely that it is not necessary for a person to demonstrate a capacity to understand and weigh up every detail of the respective options, but merely the salient factors. So that was very similar to Mr. A as well. He didn't know every single detail of what he would need, but he did have understanding of what the salient factors would be. So I've just concluded at the bottom that my conclusion is Mr. A can understand, retain, weigh or use and communicate the information required, and on the balance of probabilities, he has capacity to make the decision on his accommodation, care and treatment. Just at the end there, I've documented who I spoke to as part of this assessment, and the outcome of the assessment is that Mr. A has capacity. So the outcome for Mr. A, all of the information was sent to the Court of Protection, including the Care Act assessment and the mental capacity assessments. The doles was ended and Mr. A returned home with the care, and he was really happy about that. I've just put the case law that I discussed, particularly those two paragraphs there that I linked into my Mental Capacity Act assessment. And just the last page is a couple of links to the resources there. So the Essex 39 Chambers, the Assessing Mental Capacity Guidance, which is really helpful, and the CC versus KK and STCC, which is really helpful judgment for capacity assessments. So yeah, hope that was helpful, and thank you all for listening.
Brilliant. Thank you so much, Rachel, for sharing that presentation with us and that case example, and how it demonstrates really the importance of doing that capacity assessment to ensure that we are getting it right for people and upholding their human rights. Has anybody got any burning questions for Rachel?
I'd just like to check that the link there, is that the assessment? Because it would be really helpful to have a copy of that. I thought it was brilliant. Thank you.
The link there is the Essex 39 Chambers links, which gives guidance on the Assessing Mental Capacity Act. But the slides you'll get with the copy of my assessment, won't we, Amy?
Yeah, we'll be sharing the slides afterwards, so we'll make sure that they go out to everybody who's on the call, but we'll also add them to the Teaching Partnership webpage once we've pulled everything together. Really helpful to actually see an assessment in real life. Sorry, Liz.
No, just brilliant. Thank you very much. Well, I mean, the whole thing has been, but such a good combination of, you know, the flair of the gentleman presenting and interesting, you know, for me, as an ASC, I wasn't sure that I should be attending this, but it's been very useful. So thank you.
Good to hear it's been useful. Thank you ever so much. Okay, so we're now going to move on to, I'm going to share a video of another presentation discussing another case. This is a case of a younger adult. So hopefully we've got lots of people on the call here who are working in children and family services as well, or working with younger adults. So it'll have some relevance there. So if you just bear with me while I try and share that screen.